And the first speaker that we have on the panel is, I would say, a guest an honor, Mans Jacobsson. We had him before. He has been a CEO of the International Oil Pollution Compensation Funds for 22 consecutive years. He stepped down in 2006, and since then he is an academic lecturer and is consulting shipping companies on environmental matters. So I leave the floor straight to him, and he is the sole speaker. Is allowed to have more than the 10 minutes, so he has a longer speech. He's our keynote speaker. I will leave the floor to him straight away.
More, but not much more, even though he's our keynote speaker.
It seems we miss a PowerPoint, so...
It's not a very good start, Mans.
Good afternoon, ladies and gentlemen. I've used the title here, The Prestige Incident, Some Important Court Judgment. You could also use other titles, for example, The Paradise of Lawyers, or When Shipping Litigation Goes Really Mad. You all know about the Prestige case. It happened on 13 October 2002. The ship on its way from Ventspils in Latvia to Singapore, laden with heavy fuel oil, broke and sank in bad weather off Galicia on the Spanish west coast, and caused massive pollution in Spain and France, some pollution in Portugal, and minute pollution in the United Kingdom. And there were investigations into the cause of the incident in 3 countries, Bahamas, Spain, and France. Now, in principle, compensation should be obtained through the international regime based on the 1992 Civil Liability and Fund Convention. And as you know, the ship owner is normally entitled to limit his liability, and in this case, the limit was 22.8 million euros, and the ship owner did, as he should do, deposit that amount with the Spanish court. The total amount available under the 2 conventions was 171.5 million. And now the total claims far exceeded that, which complicated the matter. I'd just like to mention that if the incident happened today, much more money would have been available. The ship owner's limit and the fund limit would have been 50% more, and there is also a new supplementary fund which would have assured that 950 million euros would have become available. Now, the Paradise of Lawyers, the incident resulted in court proceedings in Spain, France, Portugal, United States, United Kingdom, and the European Court of Human Rights. Portugal, easy civil proceedings, only one claim, the Portuguese state, and that was settled out of court, so forget about that. In France, civil proceedings were brought in 16 courts by some 200 claimants, but they were actions of the normal type in the civil liability aspect, so they are not very interesting for the purpose of my presentation, so I'm not going to deal with them to save some time. Turning now to the real nitty-gritty is the criminal proceedings in Spain. 4 persons stood trial in the criminal proceeding before the Audiencia Provincial in La Coruña, the master, the chief officer, the chief engineer who actually disappeared and couldn't be found, and the civil servants who had been involved in taking the decision to refuse the ship to get a place of refuge in Spanish waters. Now, you could, of course, say that the claimants who wanted compensation could have brought civil claims. Yes, they could. But they would have been frozen pending the criminal litigation. So under Spanish law, they instead brought their claims in the criminal proceedings and again had to wait for the criminal proceedings to be finished. The defendants, as regards the compensation claims, included the ship owner, the P&I Club, the London Club, and the 1992 fund. The trial lasted for 10 months. The judgment was rendered 11 years after the incident. Now, all the 4 defendants were accused of causing damage to the environment, but they're all found not criminal liable. The master and the chief engineer, the court said that they could not have been aware of the bad structure of the ship, and there was no evidence that there had been any imprudent or risky navigation. The civil servant, the court said his decision to refuse the ship entry in Spanish waters, although it could be argued that was wrong, but it was technically informed, professional, and reasonable. And the fact that it might not, with hindsight, have been the best solution doesn't mean that there is a criminal liability. The master was, however, also accused of disobeying the Spanish authorities during the crisis, and he was found guilty of that and was sentenced to 9 months prison, but he had already served a considerable time in custody, as I will speak to in a moment, so he will most likely not serve any further prison sentence. Now, when a Spanish law is so that a criminal court can only rule on civil liabilities if there is a criminal offense that caused the damage. Now, in this case, of course, the court found the defendant not guilty to that, so the court could not rule on the civil liability issues because the disobedience of the order of the public authorities were not causative to the pollution damage. Now, a number of claimants have appealed, but the trouble is, as we see here now, we are now 12 years after the incident. The trials are not yet finished. Those who want compensation have still to wait what has happened in the Supreme Court, which may throw back the case again to the lower court, and we will start it over again. So it is not very satisfactory. Now, most of the claimants have been paid large part of their claims either through the International Fund or through the Spanish government, but that's another story. Now, the London Club, the P&I insurer, took a very peculiar position here. It accepted that it was liable under the Civil Liability Convention up to the amount which I indicated, 22.8 million euros. And that, they said, had already been paid by the deposit of the amount into court. But they said that claims over that amount, they call it non-CLC liability, then the claimants were bound by the insurance contract between the P&I club and the ship owner. That contract included the club rules, which provided for disputes to be settled by arbitration in London under English law. And then the club rules have, as you know, P&I insurance is not a liability insurance, it is an indemnity insurance. The insurance is only to indemnify the ship owner what he has paid. And as he hadn't paid anything here, then the club was not bound to pay anything to him. And on top of that, the club rules, the club could then, they said, invoke the pay-to-be-paid rule to avoid any liability. Now, for these reasons, the club decided not to take any part in the criminal proceedings in Spain. But instead, the club commenced arbitration proceedings in London, seeking a declaration that it had no non-CLC liability to the French and Spanish states. In this case, Spain and France decided not to participate in the arbitration. The arbitration tribunal proceeded anyhow according to their rules, and it held that Spain and France were bound by the arbitration agreement clause in the club rules, and that the club direct liability was subject to the pay-to-be-paid rule. And as the ship owner hadn't paid, the club didn't have to pay anything to France and Spain. And the London Club sought permission to the High Court in London to enforce this arbitration award. Now Spain and France woke up and resisted the application in the court and argued that the arbitration tribunal had no jurisdiction, that these states were entitled to state immunity, that they were not bound by the arbitration clause, that it was not a subject that could be subject to arbitration, and in any event, the court should use its discretion to refuse to grant the award requested. The court did not accept any of these arguments. For example, it said that the state was not entitled to immunity because the claims were really, although submitted in criminal proceedings, they were of a civil type claim, which could have been brought in a civil court by anyone. So state immunity doesn't apply. It was not basically a claim under Spanish insurance law, but it was a claim largely based on the contract between the ship owner and the insurer. So that is why the tribunal was competent to hear the arbitration in London under English law. And the court is much more sophisticated than that, but the gist of it that none of the arguments of the two governments was accepted, and the High Court granted the club's application to enforce the awards. Now, France and Spain have appealed, and this is, of course, pending in the Court of Appeal in London, and what will the outcome be, of course, I'm not going to speculate about that. And the human rights issue. The master, he was age 67 at that time. He was arrested directly on the sinking of the vessel on the 13th of November. He was brought by helicopter to the Coast Guard headquarters and then in front of an investigating judge who arrested him and set bail at 3 million euros. The master requested his release and offered a bail of 60,000. Now, 60,000 euros for a person in his situation is pretty much money. That was rejected. He appealed, the appeals were rejected. He went to the Spanish Constitutional Court, and that was rejected. Now, 2.5 months later, the London club lodged a bank guarantee for 3 million, as they said, a one-off spontaneous humanitarian gesture. And the master was released the following day, after 83 days in custody. He had to remain in Spain, surrender his passport, and report to the Spanish police every day. Not until March 2005, 2 years later, was the master authorized to return to his home country, Greece, where he had to report every 2 weeks at a police station. The master actually did return to the trial, which of course is very honorable of him to have done so. Now the master then went to the European Court of Human Rights and said that my human rights under Article 5.3 of the Convention have been broken, because that article says basically that anybody arrested or detained should be entitled to trial within a reasonable time. Now, reasonable time is certainly not 11, 12 years. And he should also have the possibility of release conditional of a guarantee, that means of bail. And the master argued that that had been a breach because the sum set for the bail, 3 million euros, was excessive and disproportionate, and that his personal circumstances had not been taken into account: his profession, his income, his assets, his previous honorable life, his family situation, and his fairly high advanced age. The European Court of Human Rights first dealt with it in a chamber composed of 7 judges, and they unanimously held there had been no breach of the human rights. They said that the seriousness of the environmental damage disaster made it reasonable to set a very high bail to ensure that the master would actually appear for trial. And it had been proportionate in view of the seriousness of the offense. The master's particular circumstances had been taken into account, and the court had also taken into account that he was an employee of the ship owner, who the court said, which of course is wrong, that the ship owner had taken out insurance to cover this type of risk. Of course, the P&I risk does not at all cover bails for masters and other crew members. The master requested the case to be heard by the Grand Chamber of the Court of Human Rights, which is then composed of 17 judges. And he then argued, there were a number of arguments, but the gist of it is unacceptable to take into account the public anger by setting the amount of the bail, and that he had not taken out any personal insurance, and the London club had no obligation to bail him out. You remember that the normal chamber ruled by 7 votes to none that there had been no breach of his human rights. But here, the Grand Chamber was heavily divided. It decided by 10 votes to 7 that they had no breach of Article 5.3. Of course, a majority ruled 10 votes to 7, but it was still a very substantial minority. And the majority's position is, of course, it is a very long judgment. And the majority said that the seriousness of the offense had taken into account the impact of the disaster on public opinion and the master's professional environment. And the majority also said that the fact that the insurer had actually paid confirmed what the Spanish court had said, that was to refer to his professional environment. And the bail had to be set so that he would appear to trial. Reference only to his own assets was not enough, and his personal circumstances had been sufficiently taken into account. In a very strongly worded minority opinion, the 7 judges said that the master had been detained for 83 days, a clear violation of the convention. The seriousness of the offense and the environmental consequence did not justify in itself that he should be taken into custody at all. And bail must set principally only taking into account his personal financial situation. And the bail here was evidently far beyond the master's personal means. And setting his bail at this exorbitant level meant in reality that his right of being set free on bail became illusory. So his personal circumstances had not been enough taken into account. Now, you know, this comes up to the whole question of the fair treatment of seafarers, and this judgment in Spain, and also in particular the Court of Human Rights, have given rise to serious concerns in the shipping community. And as we all know, it's difficult enough to recruit young people to go to sea and take a master's ticket. It may be that this is not a particular incentive to young people to go to sea and run the risk of this treatment. This is, of course, my personal opinion, and the majority of the Court of Human Rights and the Spanish courts, of course, had another opinion. We also had a litigation about the classification society, and I know my 2 friends, Hugo Savono and Francesco Siccardi, know more about that than me. Recourse action was firstly taken by in United States and France, and I think that in view of the time available, I probably have to skip this because they are not so interesting from a point of view of principle. But more interesting is that the final observation, which I would like to make of this. Of course, we all know that a major oil pollution case results in an enormous emotions in the area hurt by it, by the public opinion, by fishermen, tourism, by the politicians, by the media. And that's understandable. And it's also understandable, of course, that the criminal proceedings and the investigation into the court of the incident has to be carried out thoroughly and fairly. But the question is here whether it is reasonable to have to wait for 11, 12 years for a first judgment in a criminal case, and whether it's reasonable for the master to be kept in Spain for nearly 3 years without being able to return to his home country. As regards the international compensation regime, I think this shows that criminal proceedings is not a very good means for those who want to get compensation for their damage, because when the way the Spanish legislation is drafted, they had to wait to a final binding judgment in the criminal proceedings because there has to be proof of guilt. Whereas if claims are pursued in the normal rules under the 92 Convention, you don't have to prove the cause of the incident. It's a strict liability without question of negligence or fault. Now, the complications here arose partly because the claims were far above the amount available. Had the incident happened today, with the 950 million euros available, may be that the outcome of the civil claims as regards the civil proceedings would have become different. And you also see that recourse proceedings are very protected, and we have the issue of fair treatment for seafarers. I'm not, of course, making any judgment about the legislation in any country, but it really shows that I think governments should take a step back and think, is this really a reasonable way of solving these complicated criminal and civil issues? Or are there other ways of doing it? This would be guaranteeing everybody's justice, guaranteeing also that the dutiful claimants are paid compensation fairly and within a reasonable time. Thank you very much.
Thank you. Thank you, Mans. I think that even if 12 years have elapsed, I mean, we all know that prestige like the Erika, they both change the profile of the war fleet and the history of shipping. So it's good always to have somebody with Mans' competence to touch base on such, I mean, very, very historical events. By the way, over lunch, I had Vittorio da Monte, that was mentioned to me about the role of the classification society and the change role of the classification society of the Ajax. I would say that the classification society in the prestige case have been, taken on the floor. And then, if you want just to say a few words on that, and then we go to the next speaker.
Well, thank you, Mr. Chairman. Well, it's quite difficult to say something because we know that those accidents that changed completely the situation of the rules, and according to those accidents, not only Ajax but as well IMO decided to change the approach to the system of evolving the rules and adapting the rules to accident like this. I will say something later on, probably. Maybe it's better, just to say how Ajax is now improving and evolving his approach to the rules development, even according to some kind of accident like these two. The importance of these two accidents had given the possibility to investigate and to approach in a different way. I would like to say something later on, if you don't mind, okay?